Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
All right, we got George Moschopoulos here today. I've been mispronouncing George's name since, for sure, 2020, early 2022, when George decided that he was going to man up and come to the first TLU ski boot camp because he just got his ass kicked in a trial. And that was his wake-up call. That's how I remember it, George. How do you remember that fateful day when you stepped into that, to the Tahoe dojo on Lake Tahoe?
That's pretty accurate. I was on the heels of a pretty devastating loss on a case that I thought I was going to win, and I was looking for ways to get better. And so I saw an ad for Trial Lawyers University boot camp, and it was also a ski trip, and as luck would have it, I'd never skied in my life. So I thought,
a perfect fit.
Yeah, be great. Signed up and been enjoying the training and the yelling and the abuse ever since.
Well, the truth is, there's not nearly as, it's a much more, let's say, it's a friendlier program than it was when it started out. I've evolved as a coach and an instructor. But that first ski camp you came to, that was really great because remember we did that first boot camp. It was supposed to be at Nick Riley's Montana place because we were doing a fundraiser for his fight to change the med-mal caps in California. And so he asked me to do this to raise some money. And, it didn't work out that we got to do the house in Montana, but we did raise a decent chunk of money for the effort, and it was ultimately successful. So it was kind of nice, when you contribute to something that actually changes society for the better. So, but that turned out great because then, because we didn't go to Montana, so at the last minute, scramble and find a house to do it at, or someplace else to do it. So we started going to Tahoe, and now February 7th through 14th of 2026 will be the 5th Tahoe boot camp in a row. And Tahoe boot camp is a little different than, well, let me ask you, George, because you've been to 3 out of the 4 Tahoe boot camps, right? And so what's your favorite part? Or like people say, well, first of all, somebody would say, hey, George, what are you, the slowest learner in the world? Why do you keep coming back to boot camp? Because I think you've been to like 6 of them so far, because you've done the 3 ski ones. You did the one with David D. Robertus. You did the one on my birthday in September 2 years ago. Then you stopped by another one for a couple of days. So I think that is about 6 or parts of 6. So why are you such a slow learner, George?
Well, it could be I'm a slow learner, or, I could have critiques about the teaching maybe. No, in all seriousness. Firstly, the boot camps are an invaluable exercise or an invaluable experience for a couple of reasons. Number one, you actually get on your feet and you get to practice the skills, right? It's not just going to a seminar and hearing about other people that have done great things and hoping you can recreate them without ever getting on your feet to figure it out when it's over. Secondly, the boot camps are constantly evolving, right? So even though you're working on some fundamental skills, every time I've gone back to a boot camp, there's an evolution. It could be an evolution in the script. It could be an evolution in the techniques. It could be an evolution in the substance where you have to learn, basically like a new case. But either way, that constant evolution is just constant sharpening of the blade. Another really good thing about the boot camps are the relationships and the people you're going to meet. I mean, think about this for a second. If you're going to be trying cases and you really want to get good at it, where else are you going to find a motivated group of people that are willing to spend the money and the time away from their family, away from their practice, in an isolated setting where all they're working on is getting better? And when you do that, you're going to form relationships, right? I mean, I've always felt being a trial lawyer is kind of a solitary thing, right? Like, how many trial lawyers do you meet in your daily life? And are you around on a daily basis? And if you're not at a big firm like me, it's going to be hard to do. So for me, being around other trial lawyers and like-minded individuals is a solid thing about these boot camps.
Right. But also it's great because you make actual friends, because you know that when you get older, I mean, I'm going to be 58 in about another 6 weeks. And although I'm deceptively youthful appearing, it's the truth is as you get older, you become more solidified in who you are. You have less time to fuck around. You got, serious, responsibilities all the time. And so when there is that time where there is an opening, most people are more inclined to rest. "Oh, I'm gonna go take a week off and recuperate," and not like, "I'm gonna take a week and I'm gonna go, put on my war paint and, train 10 hours a day." Because, and it's the same, I was, thinking about like the week is going to go by, just like the 3 or 4 years of law school, depending if you went at daytime or at nighttime. Like you went to night law school, didn't you?
I did, yeah. I
Right.
worked
So we
in
both went to night school. So it's like a 4 year endeavor when, but like that 4 years is going to go by, whether you bust your ass and you work your regular job and do your responsibilities and study, or you just bust your ass, do your regular job and watch TV.
yeah.
So, it's just a result. And there's some things that no matter how evolved your training methodology is, there's still the time component, right? I mean, for me, as I've evolved, because come December, it'll be 4 years of these boot camps and probably like, I don't know, like 70 plus, maybe more. And, I focus on each one and, to make each one better than one before it, because we just did one out at Carter Mario Law Firm out in Connecticut. And it was the third time we'd done a boot camp for that law firm. And Luke Mario, who is, uh, he's a younger lawyer. He's only been practicing a couple of years, but he's done a few trials, but like he's probably done like 5 boot camps. And like to see somebody's skills progress at a young age just from training and getting on, your feet and really intentionally doing stuff is pretty exciting, because as a, I see myself in these people that I coach and train and uh, know the suffering and emotional distress of losing and not knowing what you're doing in a courtroom and standing there and just looking like, and when there's the pressure of the courtroom combined with the necessity of mental acuity to think and react with pressure is like you know is a is something that just has to learn from conditioning. But like when you say like what observations have you made, or from your perspective have you seen? Because I know the evolution because I teach every camp, right, every program, and I know what I'm trying to do in every program. So, but what evolutions have you seen, George?
Well, before I answer that, I just want to pick up on something you just said, where you said, the mental acuity, the stress, and everything that's required in trials. And something that I've picked up as these boot camps have gone through is, everybody, I used to think that, hey, look, if I don't have the exact things I'm going to say to that jury when that group of 30 or 40 just walk in for that first time, it's okay. I'll figure it out. I'll figure it out when they're there. I'll know what to say then. Okay. I'll rise to the occasion. And the truth of the matter is, I am less likely to rise to the occasion and more likely to fall back on my training. And if I don't have any training to fall back on, and I haven't done any reps, or I haven't thought through the scripts, or I don't have objectives thought in mind of what I want to accomplish, I'm not falling back on very much. So that's one of the reasons why I keep going back to the boot camps, because even if they didn't evolve, just the opportunity to get reps and to get additional training and to kind of hone and refine is super important. As far as the evolution of the boot camps themselves, we've gotten tighter in terms of like, it's become more about uh practicing one kick 10,000 times as opposed to 10,000 kicks one time, right? So we get really focused on the first 5 to 7 minutes of jury selection and building rapport, which is hugely important. And you know what? A lot of times you don't have 5 to 7 minutes. And a lot of times you're lucky to get 1 to 2. So what are you going to do then, right? Got to think that through that. The cross examinations, they used to be where we would have like these, 3 and 4 phases of cross examination. Now we're getting really focused on hit your 3 points, establish your 3 points, build them up, and we kind of basically go up to the cliff. And then of course it's up to the individual lawyers in the individual cases to kick the witness off the cliff with whatever goods they've got. So that's another evolution. the other evolution is we've transitioned from, you know, like a criminal case to, you know, a trucking case, which is really cool, right? Like how, and there's lots of nuances in there too, right? For example, are you going to vilify the truck driver who's the guy that's doing the 8 to 5 and just trying to, you know, barely get by? Or are you going to be focused on the corporate representative? And how do you do that in opening? And how do you do that in cross-examination? How do you build that focus, right? I mean, those are all things that I've seen evolve over time, which I think have been great ads.
Well, we got the Joe Freed trucking boot camp coming up August 12th through 16th. That I honestly, I'm most excited about this boot camp for several reasons. One, it's at the Paseo Hotel, which is where we do the TLU Huntington Beach, but it's great because everybody being in the same hotel is really great, and it's a small hotel, and so that allows us to have almost dominate the space. But, we be able to do breakfast every morning from 7 to 8, train from 8 to 12:30, get lunch as a group from 12:30 to 2, and then have a nice dinner because there's so many nice restaurants right within walking distance. So I'm excited about that. But really, really the preparation with Joe on people's cases and the preparation of now it's a 5-day boot camp instead of 3 days. And it's very set starting out with, training the skills of cross-examination, and then the performance skills in the afternoon, and the next day doing, different parts of the performance skills, doing the cross again to really build the muscle memory, to build the skills. And like the 6 weeks that I think we're 7 weeks of training ahead of time by Zoom. And, most of the people show up, some don't as usual. Some are like, I'm too busy to train. I'm like, I totally get it. Whatever you can do. And then they're going to show up and they're not going to get nearly as much as the people who have built the accurate mental representations of the skills that they're learning before they get there. Because when you get there and you stand up, it's like you don't know your stuff very well. It's like the pressure, it doesn't help clarified thinking. Let's just put it that way. And, but we also cover witness prep and direct now. And then we morph the skills of cross that we learned to do the cross of the defendant truck driver, showing people how to create space or create an illusion of, the trucker driving down the road. And so that way it becomes even a three-dimensional hologram, not just in opening and closing, but to train that stuff on direct and cross too. So that you learn the skills to make the entire story come to life in front of the jury, because I think that's what the skills of the greatest trial lawyer is the ability to transport the jury, to take the jury out of that box and put them there by the side of the road when the crash happens, or put them in the people's house when the people, when the plaintiff's recovering and they're suffering. So they make them witnesses to the devastation, to the suffering. Because once people witness it, it's a little harder for them just to, not care. It's like today, like, immigration. When people witness those masked idiots grabbing people off the street and terrorizing them, it's like, hopefully it affects people viscerally. Some people I know are going to be, yeah, you know, police state, military state. But for most people, it's pretty offensive to watch this stuff happen, to witness it. So the goal is to make the jury witnesses to the event. And that's what we continue to do, continue to train. And now we, doing it now in conjunction with like a Joe Freed, because now everybody's working on a trucking case, right? So we're building, like you said, find these like-minded people. Well, there's like 15 people, actually it's still 14. We're waiting for that 15th one to raise their hand to show up. But besides those people participating, I think we have like 10 jurors coming that's going to sit and observe, and you're going to be coming off a trial, and so time. So you're going to come in and and it's in Orange County conveniently for you, George. So you don't even have to stay at the Paseo. You can just come in and hang out and sit and participate a little bit. So that works out pretty good for you. Perks out pretty good for you. So, but let's talk about your journey as a trial lawyer, George, because you didn't start off with this desire to be a man standing in front of a group of people trying to persuade them. You started off a little different. So tell us about the humble beginnings of George. And did I say it right? Moschopoulos? Because I've been knowing George for about 4 years now, and I say Moschopoulos. He's like, it's Moschopoulos.
Yeah, well, it took me 4 years to correct you, or maybe it took you 4 years to learn.
We got it.
We got it.
All right.
Yeah, so, if you'd asked me when I was growing up if I was going to be a trial lawyer, that was the furthest thing from my mind. That's not what I had in mind at all. I grew up, son of Greek immigrants who immigrated here in the 70s, and they immigrated here with a very singular purpose, which is my dad wanted to become a math professor. my mom followed suit and taught math at the local community college. So growing up, there was a very heavy focus on math, and math is king. And so from an early age, I thought I was going to be an engineer. And when I graduated high school, I went to college to become an engineer. I went to grad school for engineering. And in my early 20s, I found myself working as an engineer and bored to tears. So I enjoyed the study. I didn't enjoy the practice. And I was looking for ways to challenge myself in ways that I thought that was interesting. And I thought, well, um, law school might be a good fit because it's completely different from what I'm doing. It can be adversarial, and who knows, maybe there's an opportunity for me to combine law and engineering, and there's some opportunities in that. So I went to law school at night while I worked during the day as an engineer. And by the time I graduated, I still had no idea whether I was going to be a trial lawyer, whether I was even going to practice law.
Oh, what a surprise, George. You graduated law school without having any idea what you wanted to do.
Yeah.
Wow, that's such a unique thing. I mean, if people go to graduate from law school, they have most. I mean, I think that's pretty typical. Very few people have a vision for their lives when very few people have a reason why they went to law school other than to keep going to school. And then when they get out, they're like, what am I gonna do with this?
Right.
I mean, like becoming a plaintiff's lawyer, nobody ever talks about that in law school. You never have any professors that are plaintiff's lawyers. Usually, like I had professors that they were tort lawyers, but they worked at big law firms to defend the torts, you know, and or they were prosecutors. But no, there was no. I mean, there was no plaintiff's lawyers that were, especially of any decency, none that you would like want to emulate, right? So yeah, I'm a plaintiff's lawyer, and they're coming in and they, shoddy as hell. It's like, who the fuck wants that life? It's not like you had a Brian Panish or a Nick Rowley come and teach you and be like, let me tell you what's there for you if you want to pay the price. So
Right.
that's not surprising. So you come out of law school, and now at this time when you graduate from law school, you're already married and have a family or starting a family. So is that
Well, I'm married. Yeah, my wife and we met in law school, and by the time I graduate, my wife took the bar, passed the bar 6 months before me. We had our first. Then I take the bar, pass it. So I've got a new baby, a young family, two sets of law loans, and no idea what I'm going to do.
you better get to work, son? You better
Yeah,
figure it out.
yeah.
So tell us about the journey of figuring it out.
So I had an engineering practice when by the time I graduated law school. I figured maybe I'll just, put the law school or law degree on the shelf and the bar license on the shelf, and who knows, it'll look cool. It'll be a great dinner piece or conversation piece. Then 2008 hit, and if that wasn't enough, the meltdown basically cratered my engineering practice, and I didn't know what I was going to do. And I had an evidence professor who had big law experience, just started his own firm. He was going to be he's a litigator, somewhat of a trial lawyer, but primarily a litigator. And, him and I bonded and kind of gelled. And I asked him if he'd let me carry his bag for about a year or two just to kind of figure it out, right? Because I knew if I wanted to practice law, what I knew is I knew nothing about the practice of law. So I did that. I followed him to mediations.
How
followed him.
old are you at this time, George? Because this is your second career, so you're not exactly a young pup 24-year-old at this time, I'm sure.
Yeah, at this time, I'm about 32. I'm
Okay,
about
so you're
32.
still relatively young.
Yeah.
Okay.
And so I did that. I got to watch him take depositions, got to participate in mediations. And that slowly turned into paying gigs. He was a business litigator. So everything he did was business litigation, business torts, fraud, partnership disputes, things like that. And one of the benefits of having him as a mentor, which I strongly recommend, if you're going to do this, find a mentor. And when I say a mentor, really it's plural. Find as many mentors that are doing things that you want to do and try to soak it all in through osmosis.
So just hold on, but on the mentor thing, because people always have so much difficulty because, when you don't have anything to offer somebody, as you're going up to and asking them to help you, it's a little difficult for some people sometimes. And so that honestly is, one of the reasons, one of the driving forces behind Trial Lawyers University. is that during the pandemic, it gave the greatest trial lawyers in the country a chance to almost act as mentors for so many people and help guide them along the way. And I think that's really continued after the fact in person, because when you meet people, especially these younger lawyers, meet these great trial lawyers, and most of them are very giving people, are very kind. Now we have our share of assholes. There's no doubt about that, and everybody knows who they are. It's not like we ain't gonna call out names, but everybody knows who the prima donnas that walk around like they're so much better than everybody else, and they look at you like you ain't shit. And it's like, but for the most part, they're real, you know what I mean? Obviously, like the exemplar of all the great ones is Brian Panish. I mean, because he's the goat of goats, and he is just the nicest person, and he's nice to everybody, and he is, walks the walk and talks the talk every day. And so, you know, and so if you go to these conferences, especially TLU, where it's, people are like, "Oh, it's 4 days." I'm like, "You don't have to come for the whole time if you don't want to." And I think you're an idiot for leaving early, because that's where the great relationships are made. And so, like, we just did our one, a couple months ago that unfortunately you weren't in because I was in trial. It's the only excuse that's acceptable to us. You're kicked out of the tribe. If you're in trial, but don't tell me I'm having my grandchild or some nonsense like that that's prevent. Like, you're not having it. Your granddaughter. Okay, anyway, so my point is that to get mentors, you got to have relationships. Relationships you have to invest time in, okay? In person. You can't develop relationships, or you can, but it's real harder on Zoom. But when you meet people and you connect and you sit and have breakfast and lunch with them, by the time those 4 days are over, you actually know people. You actually have friends. You've discussed your cases. People come invested. And that's another thing that these boot camps do. It's like for the, if the people are coming to the boot camp with Joe Freed, let me tell you, Joel Freed's gonna be a lot of people's mentor after that boot camp. It's just like it's not, and he likes that too, because he loves to teach and he loves to help, and I mean, and he's like right with Brian Pan. I mean, even maybe more so than Brian Pan. It's like Joe Freed, exemplar human being, trial lawyer, kind person who's constantly giving and helping, and that's why this thing is gonna be so. I'm so excited about it, because it's going to seriously transform so many people's lives and break so many bad habits, create new ones, create great relationships. But that's the way you got to find mentors. You got to put yourself out there. You can't just sit and wait in your office and sit and stare at the phone and say, "I wish somebody would help me." No, it, don't- it ain't gonna work that way. You get off your ass, go out there and talk to people, make friends, and you'll be surprised when you got an open heart and a giving heart how many people are there to help you. So that's what I have to say about mentors. Find mentors. Very good. All right, keep going though. So you got your mentor. You
So I got
stress
my
mentor.
mentor. He helping me out, but he's not, and he was helping with business litigation, which is great. He was teaching me how to write briefs, which is also great. I mean, you have somebody who has, my mentor was a Cornell Law grad, worked at BigLaw for 15 years before going out on his own. So having that as your guide to drafting briefs and putting pleadings together is really helpful. And then I was still not sure, though, what I wanted to do. I started getting some paying gigs. I started getting some cases of my own on an hourly basis, but I wasn't really sure if business law was going to be it for me. I enjoyed it, but it didn't also necessarily fulfill me. I looked at some other practice areas. I was a criminal defense lawyer for about 6 months.
That's
Hated,
a hard job.
yeah,
I did it for 17 years. I mean, I didn't hate it, but it was very stressful, didn't pay shit, and I was aging very quickly. So, and
yeah.
just not having fun. So I was
Did
like,
did not
I'm gonna
enjoy
need a change. I'm gonna need a change.
did not enjoy it. I thought with my engineering background, construction law, maybe even patent law would be a great fit. So I dabbled a bit in that. Bored to tears. Did not like that at all. Wasn't fulfilled. And then around 2008, maybe 2009, I had a buddy of mine from law school who was kind of trying to figure it out the same thing. And he said, "Hey, there is a new lawyers seminar being put on by CALA in downtown LA." I was like, "What's CALA?" And he said, "Well, basically the plaintiff's bar in Los Angeles." And I said, "The plaintiff's bar? You mean like PI law, like personal injury?" He said, "Yeah." I said, "Well, I don't have any interest in that. Why would I want to go do that? PI, like who does that?" he says, let's just go and let's just check it out. Let's see what they have to say. And there was a panel there of trial lawyers that was talking about trials, was talking about, the things they do, helping people. And I remember two speakers in particular. The first was Mike Alder, and he was talking about just the process of trials and why it is he does what he does. And when I heard him speak, I was hooked on the whole idea of trials, but I wasn't necessarily hooked on the idea of PI. There's just coming from an engineering background, having just graduated law school, I was like, you know what? The last thing I really want to do right now is take on a third body of knowledge in medicine. Like, I'm set. Like, I don't necessarily want to do that. And then there was another speaker, Doug Silverstein, who was talking about employment law. And I said, well, employment law, what's this about? And he was talking about things like sexual harassment and disability discrimination and retaliation. And I said, we're in 2008 or 2009. Who's discriminating against anybody these days? Who's retaliating against people? It just goes to show like how little I knew and how naive I was. But between those two, I was hooked. I said, I want to try cases, and I think employment law is where I want to be.
I think we're all selfish. We can count on that about being an animal. It's a selfish, self-serving animal. So let's use that environment for our benefit.
So you make these decisions, and it's one thing to decide what you want to do. It's another thing to actually do it and become it. And so what course of actions do you take to follow this new vision?
Right. Well, the learning is in the doing, right? You're not going to go out and get a book and say, I want to be an employment trial lawyer. How do I do this? My buddy said, I want to try this employment law stuff too at the same time. And he was really good and continues to be really good at marketing and getting the cases. And I was more focused on trying them. So he'd get them and we would work them up together. So we started getting employment cases, and we really didn't recognize the value of, or the ins and outs of what it takes to put together an employment case. Employment law is very technical, which, by the way, my experience litigating business cases helped a lot, right? And so you start putting together these cases, and because you don't have a lot of experience and because you're not recognizing what a good value case is and what one isn't, you start getting cases where you start settling them, and you're not really sure about when your first trial opportunity is coming. And I always thought that the best employment case to try would be the one where with the best facts, the best witness, the best damages. And after a couple of years, I started realizing those cases aren't getting tried because they're getting settled. The cases that are most likely to be tried are the ones where you have disputed facts, or you have some credibility issues, or you have some issues about this person doesn't have any damages, so why would we give any value to it? And those were the opportunities to try cases. And it didn't take long. After about 2 or 3 years, I got my first opportunity to try a case, and it checked all the boxes of the cases that I wouldn't want to try.
Okay. And so how's that experience? Because a lot of times people go to trial in really shitty cases just because they say, oh, I want to get some reps. I'm like, you're getting reps getting your ass kicked. You're getting reps on rebuilding your ego after you get pasted to the ground. And, and I think that, a person with some character and intestinal fortitude and grit can handle a few poundings, maybe a few. But when it gets past a few, very few humans can handle five defeats. Bless you, 5
Thank you.
defeats, 10
Yeah,
defeats in a row.
and I thought I was walking into a slaughter on my first trial. I'll tell you real quickly kind of the facts of the case. It was a disability discrimination case. My client came down with fibromyalgia, which is very painful, debilitating physical disability. She's working an admin job in a small company. And she comes in and she presents this note to her supervisor that says, it's a doctor's note. It says she has fibromyalgia. Please give her an office on the first floor so that she doesn't have to walk up and down the steps. And there were some other minor accommodations. I don't remember exactly what they were. And a week later, she ends up fired. So I thought initially this is going to be a great case, right? So as discovery develops, what we figure out is a week before she presented the note to her supervisor, the CEO of the company had sent an email to her supervisor asking, where are we on eliminating the plaintiff's position? Well, that email kills the case, right? Because how are you going to show now that her disability had anything to do with her losing her job when a week earlier the CEO had said, I want to replace her, right? So I did what I thought any trial lawyer in my situation would do, which is
Run.
I try to settle the case, right? So I make an offer. Yeah, that's code for running, trying to settle the case for a very low value. So I made an offer of what I thought was an opening offer, which I thought was very reasonable, $50,000. Hey, let's settle this case for $50,000, knowing they're going to come back and they're going to say, I got nothing. Maybe we could settle it for $25,000. Okay. I got nothing. I got crickets. I got silence, right? Which is also trial lawyer code for go try your case or dismiss it. I went back to my client. I said, look, I've never tried a case like this before. Maybe you should get someone that's more experienced. I also explained to her, I think this case is very difficult in my opinion. But that's why you don't have to accept my opinion because I don't have a lot of experience. You should maybe go talk to somebody else. And the other thing is, I don't have any money to pay for an expert for your case, right? So why, this does not look like a great scenario for us to go to trial. And she says, well, you know what? I trust you. And I also had my buddy from law school. We were both on the case together. And we were kind of scratching our heads trying to figure this out. And she says, why don't you just go try the case and do the best you could? Which is really not what I wanted to hear. I was hoping she would give me a reprieve. I was hoping she'd go get another lawyer that actually knew what they were doing.
No lawyer that knew what he was doing would take that piece of shit case. That was the problem.
Well, that is the problem. Yes.
That's the problem. So what happened, George?
So what happened is I start prepping the case for trial. And I'll remember 2 nights before trial, it's about 11 o'clock at night. I'm sitting in my conference room, and there was a stack of documents that I had gotten from a subpoena to a third-party human resources professional that this company was using. And I was like, well, I've never looked at these documents. If I'm about to go to trial, I might as well just at least thumb through all of them to say I did it. I went through. And the 6th to last page of that stack of documents, which, again, I don't remember how many it was. I think it was like 1,100 documents or so. But I remember it was the 6th to last page. There's an email in there from this human resources professional to my client's supervisor about 2 months after she's been fired. And the email says, hey, I understand new employee, which, by the way, new employee happened to be supervisor's younger sister. So after my client's fired, supervisor hires her younger sister. So the email says, I understand that new employee has the exact same title as my client, is doing the exact same job as my client, and is reporting to the exact same person as my client. Now remember, allegedly this position had been eliminated, right? Based on the CEO's email. So human resources expert or professional says, I recommend that you change new employee's title, that you come up with a job description that has different duties than what my client was doing, and you change her reporting structure so that she reports to somebody else. And now here's the kicker. By the way, after you've read this email, please delete it. Smiley face. Right?
Apparently they messed up on that one, huh?
Well,
actually, they deleted it, but this person has sent it didn't.
That's exactly right. That's 100% right. And I'm sitting here at 11 o'clock in my office thinking, or in my conference room, and I'm thinking, does this say what I think it says? Does this mean what I think it means? Is it just too late? Am I just too stupid to really know this? I mean, does this kind of stuff happen? So 2 days later is opening statements. We go through jury selection. I go to opening statements and I stand up and I say, what you're going to hear is that 2 months after she's fired, they're fabricating evidence, they're deleting evidence, they're coming up with new job descriptions, they're changing who she's reporting to. Now, mind you, none of this stuff had been discussed in the depositions because I didn't know it was out there. So defense counsel's hearing this for the first time. And so his opening statement after mine is, hey, all that stuff that this guy's telling you that he's going to do, this stuff about fabricating evidence, new job descriptions and things like that, those are promises that he's making to you. You need to hold him to those promises. And if he doesn't deliver on those promises, he loses. I was like, great. Because that was, opening statements were on a Thursday afternoon, and by the following Friday afternoon, I had the witness with whom I could go through these emails. And sure enough, through supervisor's mouth, I got all this into evidence. And from that point on, the wind was at our backs and we were running downhill. And it was a great lesson in trial work.
So what did you get for a verdict, George?
So on that verdict, we got, the total verdict was just over 6 figures. It was about $75,000 in compensatory damages. And we got punitive damages of about $50,000.
We should watch some of the D. Robertus's case analysis on punies, but keep going.
Yes, I've been a student of his for sure. But there's a but, and this is the nice thing about employment cases. The attorney's fees that were awarded after the fact were almost $400,000.
All right, so you finally have some money. This is exciting.
Yeah, finally.
I remember that first case I made some money on. It was a civil rights case I did with my buddy Steve King. We got like $100,000 verdict and $100,000 in costs, and my cut of everything was like $40,000 for 2 weeks of work. I'm like, yippee-ki-yay! I found how to make that much. It took me almost a whole year of criminal defense law to make that much money. I was like, wow, this is going to be cool. But civil rights cases are not that easy. They're a little tougher than most employment cases when you're suing cops. But so, George, here's what everybody wants to know. And that trial was in what year? 2009, 2010?
No, that was in 2012.
2012. Okay, so we're 13 years later. So how would George Moschopoulos, what would George do differently now, and do you think it would make a difference in your results, besides just inflation?
Yeah. I think being able to tell the client's story in a way that connects with the jurors, right? Being able to, you always want to say, back then it was all about sell the bad, right? How bad is their life? What did this mean to lose their job, right? Would it sell the inconvenience, the grief, the anxiety, all the things in the jury instruction for non-economics? Check those boxes. Did you feel any inconvenience? Were you inconvenienced at all by losing your job? Well, tell us about that. So now I can stand in closing argument and say, she talked to you about the inconvenience, so you should give her a lot of money for that, right?
You know what we call that, George? We call that the mommy story. Mommy, I'm a victim. They hurt me. That's usually not the story that drives the big damages. So what did you figure out would be the story that will drive the big damages?
The story that drives the big damages is not the bad, but the glad, right? You sell the happy times, what it was like before, and what she's doing now, not to wallow in self-pity, but to pick herself up. That's the story that jurors want to reward. And if you bring someone in saying, oh, I lost my job and it hurts, and I really loved my job because, after all, who doesn't think a job's supposed to be fun, right? And give me a lot of money, you're not going to get a very big verdict for that. You'll win okay, but you're not going to get a great verdict.
Okay, so what I meant, George, what I was really referring more to, I mean, obviously the juxtaposition before, the before and after, but also, really it's a story of betrayal, right? The trusted relationship intentionally broken for the wrong reason. That's where the friction, that's why Panish, I'm like, Panish when I first met Panish during the beginning of the pandemic and started to get to know him a bit and started to see his results, I was like, Panish, what's your greatest skill in the courtroom? I mean, is it opening? Is it closing? Is it rex? Is it cross? And you know what Panish says? All of them. And I'm like, okay, of course, superstar, all of them. But if you had to pick one of them, he's like, cross. I'm like, really? Why? He's like, I know how to find the friction. And the friction is the betrayal, right? And so, and that's why the lies, the betrayal of trust. When you find that, and, and obviously that's where the punitives comes, right? The punishment is the lies. And so that's what I was kind of referring to. And that's, because like Dave Clark out in Omaha, he's always been my mentor. I started studying with him right before that civil rights case I was talking about with King, because I met him at Jerry Spence's last trial in Des Moines, Iowa. It was a auspicious meeting. The first time I met him, I was all excited talking about, I'd just been to a local trial lawyers university workshop on voir dire in Chicago. And I'm talking to this other buddy of ours that's a TLC guy, but Clark was like an original TLC guy from 2003, or I'm sorry, 1993, because I was there in 2003. And I was like, and then Clark, I just say hi to him. He turns around and looks at me. He goes, I got a splitting headache, and the sound of your voice is making it way fucking worse. Would you mind shutting the fuck up? And I'm like, you know what? I appreciate your straightforwardness, and I will shut up, because I can appreciate, like, I'm a little annoying at time when I'm excited. So that's what I was talking about, the betrayal story. But that's
Well,
moved into your the juxtaposition of the before and after, but also the defendant's conduct really is where it drives the damages for the big
well,
numbers.
every employment case, I think every trial, but what you said holds true, particularly in employment. Every employment case is a story about betrayal. You don't have to overtly say that, right? Like, I mean,
Right.
it's kind of interesting, right?
When you
Like
say it overtly, it takes it all away. It's like,
right.
folks, this is what should make you angry. So get angry. It's like, no, let me show you what happened. And
Yeah.
I would be surprised if you are not angered by what these people did and are trying to do.
Yeah. But that has been I can say that in every trial I've done, whether it's an employment case or not, because I've done some PI cases, even some business cases, it's a story about betrayal. There's a consistent theme. If you're representing a plaintiff, there's a story of betrayal there for sure.
What do you think that verdict would be today? That same case, with your skill set and your ability to tell the story and properly structure it. What do you think?
Well, I can tell you my ask would have been significantly higher, and I think the value would have been probably tenfold.
All right, tenfold. Now, along this journey, how many jury trials have you done? Would you estimate? Not that anybody keeps track.
I don't know, maybe jury trials, maybe 10.
Okay, and so now, but you just recently just got out of trial last week, which was part of the reason why you missed the greatest TLU beach ever, greatest TLU ever. I don't want to harp on that, but George missed it, and he was nice enough to come by ahead of time and have would you have lunch or dinner with us a couple of times during the boot camp. But what was this most, because you just got out of trial like 2 weeks ago with our other friend Jared Ermis, that you guys kind of met up at the D. Robertus boot camp on employment in January, and he was working on this case. And so tell us about how it is. What was this case about?
Yeah, that was a really interesting case. Jared and I met.
You just tell us the story. We'll decide if it's interesting or not, okay?
Jared and I met actually right behind you, right there. We were sitting on that couch. He was telling me about this
Right
case.
there.
Yep, at the boot camp, at the David D. Roberts boot camp. So, case is filed against Los Angeles Unified School District. LAUSD, I didn't know this at the time. It's the second largest school district in the country. It's so large that it has its own sworn police officer or police department, right? And within the Los Angeles School Police Department, there are sworn officers and there are unsworn officers. They're called school safety officers. So they have a uniform, but it's not the same thing as a police officer. They don't have a gun. They don't have a badge. They're not academy trained. Okay. Their primary job is to be a uniform presence at the schools. So our client, his name is Eric Jones. He worked for the police department. Well, he had worked for the district for just over 20 years, 23 years. And one day he's closing a gate at his school, injures his shoulder, requires surgery, gets the goes out on leave, comes back. As he comes back, he's working this modified desk duty. And as he's working the modified desk duty, his doctor writes him a note that says, you have reached permanent and stationary status. You are, and meaning you're never going to get any better. Your situation's not going to improve from what it is. And one of your permanent restrictions is that you cannot defend yourself from personal attack. And so I recommend you don't get into any physical altercations because you can't use your right arm, which is your dominant arm. It's essentially what his doctor note says. So the police department gets this note and says, well, there's nothing we can do for you. Too bad, so sad. Sends him home. He clicks down his sick time that he's accumulated over 20 years of service. And as soon as his sick time dwindles to zero, he's essentially terminated. And so we filed the suit. Actually, my co-counsel, Jared Ermis, he originated the lawsuit, filed it basically for disability discrimination, failure to engage in a good faith interactive process, which just means when you have a disabled employee, the employer is supposed to sit down and they're supposed to talk to the employee in good faith to see if there's someplace else that they could fit this person in, their 60,000 person organization. And the third claim, or there were some other claims, but the third main claim was failure to provide reasonable accommodations.
Cross-examination of the defendant in the defense's case in chief to affirm what the jury's feeling and thinking.
I've been going to Trial Law University for years now, Huntington Beach, Las Vegas. It really is the only conference, I think, in the country. You can forget all the rest of them.
All right. And this whole case, so how does it evolve? We know what the story's about now. And so tell us about how, you get involved, but also the trial, what's the story of this case, George? Because I know because I was talking to you throughout the thing. So we had some little bumps in the way. It wasn't a smooth victory.
No. They rarely are. So a couple things, right? Like, first and foremost, when you're looking at this case and you think about a school safety officer, and this came up in the focus group that we ran on the case, regardless of what's in a written job description, regardless of how often he's actually called on to defend himself, there is an expectation that a school safety officer is going to possess the ability to protect himself from attack. Even if he never has to do it, that expectation is there. And you really can't remove that or divorce that from the case. So that was a fact that we had to work around. Another issue is that, you've got all these images of the children, right? And the teachers and the protection of like children and teachers. And is this something that they're supposed to do even if it's not in their job description? And during jury selection, we had a juror come in who sat down and who happened to work for the district. Okay?
Mm-hmm.
So I asked her if she had any experience. Not only did she work for the district, okay? She was a special education assistant who had retired from the district and had worked there for 30 years. Okay? So I asked her if she had any experience interfacing or interacting with the school safety officers. And she said, oh, yeah. I asked her to tell me about those experiences. And she said, there were a couple of times where we had unruly students and they had to get in there and separate those students, and they're an integral part of the team that we have on staff and on site, and I rely on them to physically intervene and get physically involved. And now I'm hearing this and I'm thinking like, well, I guess she's not going to serve on this jury. And more importantly, after she's gone, all these other jurors have just heard from a disinterested witness who had worked there for 30 years about what the job is really like. Are they going to forget this, right? And I don't believe that for example, if you have a juror that's going to get up there and say, I don't believe in money for emotional distress, I don't think that poisons the well. I don't think that's enough to change other people's beliefs. But if you're talking about something fact specific like this, where this juror is basically now they're not the defense's non-retained witness, and she just shared her personal experiences with everybody else, I don't think they're going to be able to forget that. So that was difficult. That case evolved right then and there, because when I sat back down, Jared actually leaned over to me and said, "Listen, I don't think I think she could be a good juror for us. I think we just need to reframe this case, and we need to refocus on the available accommodation that didn't require our guy to have to get physically involved with interactions between students." And that was the desk job that he had been working for the past basically 2 months. So that was the first hiccup, pivot, and refocus. And and that was right during jury selection.
So did you make the pivot?
We did. We kept that juror on, and from that point on, we refocused the case to be about the available accommodation, which was a desk job, as opposed to arguing he could just go back to his school and do business as usual and continue serving as an SSO.
Okay, and so let's just get to the bigger picture, George. How would you rate your performance in this trial compared to trials of the past? George Moschopoulos, trial lawyer.
Moschopoulos.
Moschopoulos. I knew that. I'm fucking with you. I can't believe you're so childish. You had to correct me. Go ahead.
I would rate it as better and constantly improving, but with a lot of room to grow. And there is never, like, I feel like as trial lawyers, if you ever think to yourself, wow, I've arrived and
I've got it all figured out.
and it doesn't get any better than this, and there's nothing better that I could do, then I think you're
fucked.
you're at the beginning of the
Because
downhill slope.
you think you know everything. I love these people that say, I don't. Besides, it's talking to this one guy. Say you got to come to the. What have I got to learn? I'm like, you know what? I felt sorry for the guy. I'm like, dude, you're a lost cause. Like, if you think you know it all, if Brian Panish is continuing to work to learn to get better, I don't know anybody that shouldn't be working and getting better then, because he's the best. And he's working every day because he wants to continue to be the best. You think Michael Jordan stopped training, after he won the championship and said, you know what, I got this figured out? Or he's like, what's next? How do I get better? That's the only way to keep improving. So.
No, 100%. I mean, definitely. I definitely did a lot of things better than I have in other trials, but I can still see a lot of room to grow, a lot of room to get better.
So tell us how the trial, because I was talking to you on the phone while jury was deliberating. And actually came and saw you for a minute, but unfortunately it was like the slowest trial in the world. And it was like jury selection was like 5 days, or I don't know what it was. I went there down jury selection and saw you, ask a couple questions. I'm like, well, this is exciting, but I had to get back to Vegas now because unfortunately, I got work to do myself. But I tried to catch a little bit on the video, but unfortunately, it only had sound and no video that day, George. I didn't get to see your closing argument. So tell us, when the jury's deliberating and you're getting some notes, because I know we were on the phone during it. So give us a little bit about that experience before you get your verdict.
The worst day of the trial, for sure. Because between jury selection and deliberations, we had good days, right? We were teeing off on all their, on all the adverse witnesses. They didn't score any points on our client during cross-examination, and he was up there for a long time. So by the time we wrap up and the jury gets the case, we're feeling pretty good. And then the questions start coming in, right? And, if it's the question like, can we have a calculator so we can figure out damages? That feels good. But we weren't getting those kinds of questions.
What questions were you getting, George?
So we had a cause of action for retaliation, right? That basically the district retaliated against our guy for requesting a reasonable accommodation. And the second question on that verdict form is, was there an adverse employment action, right? Like, did the employer take some action against the employee's employment, with termination, sending him home without pay or with pay, suspension, anything? And you know what? 4 weeks earlier, had I asked opposing counsel to stipulate that there was an adverse employment action, 50-50 chance he might have stipulated, right? Because the facts are so strong that there was. And in fact, that's one of the reasons why we even put that verdict form first, so that they could answer the easy questions in our favor first, right? And the question comes back, it says, we didn't find an adverse employment action. We answered it no. Do we continue answering the same the next questions on this verdict form, or do we go to the next verdict form? And I just thought, wow, okay.
You're an idiot.
You know that feeling when you're going over a hill in a car and your stomach just kind of comes up to your throat and you just, you know, you feel sick. I was like, how could this be? I thought we were running downhill with the winds at our backs, that we had built this huge lead. And in my mind, I'm thinking, this isn't a matter of whether we win. It's just a matter of how much. And it just goes to show you, no, how I was so wrong. And yeah, we were talking as those questions were coming in, and I was like, oh, this is great. And then the questions continued to come in, and they weren't getting any better. They were like, I'm trying to remember what the next one was. Oh, but it was like, if we don't find for this cause of action, right, do we still have to answer the next cause of action? And by the time we went to trial, by the time the jury got the case, there were 4 claims. And I was like, I think, and this was around, I think, right after lunch, you and I were talking. I was like, I think I'm looking at a defense verdict here. This is not looking promising at all. So that was waiting for the jury verdict or for the jury to deliberate, getting the questions, having to answer those questions. I mean, that's the other thing too. You get the questions, right? They're not self-executing. Now the judge wants to hear from you, and he wants to hear your argument. So you have to go discuss how you want to respond to the jurors' questions, or whether you want to respond. It's just talk about, mental acuity, intestinal fortitude, all coming together. It was not fun. It was not fun.
Okay, but the verdict was fun. So which cause of action? Tell us how the verdict came down.
So the verdict came down. We prevailed on one cause of action.
Which
we prevailed on the cause of action for failure to engage in a good faith interactive process. We did not prevail on the other 3 causes of action. And the jury awarded a total of $3 million their total verdict was $3 million.
What was your pretrial offer? The highest pretrial offer?
The highest pretrial offer we got was mid 6 figures. That was all the county council would tell us. We can get you mid 6 figures all in, including all your damages, all your attorney's fees, and all your costs. And that was delivered about either the week before or 2 weeks before we started trial.
And what do you think your attorney fees and costs are going to come out to in this case?
About 1.3 million.
All right. Well, it's a good thing you didn't take their mid 6-figure offer, George. Sounds like your engineering and math background has been helpful in making that decision, huh?
Yeah, right. And my fortune-telling instincts were right on point, because what trial lawyer can't predict exactly how a jury's going to come back?
Exactly. That's why, you need to do one of those big data studies. Could have figured that number out ahead of time. And what was your ultimate demand? What was your last demand, if you recall?
Right before trial, in response to theirs, we asked for $3.5 million plus attorney's fees and costs.
Okay, so the county council was pretty accurate with their. I think they saved $500 million by going to trial with you, but then they probably ate that up in attorney fees, so it'll probably come about even. So, not a bad day for them overall. Not a bad day for everybody's happy now, right there. The little middle sweets. Was the defense happy with the verdict?
Well, I imagine he was a little bit disappointed. Listen, there were 2 defense counsel, or two lawyers trying the case, plus the 3rd county counsel. And one of the lawyers, the senior partner on that side, is a guy that's been around for a really long time, one of these guys that has a lot of presence and charisma around a jury. It's got like a 5-digit bar number, tried a ton of cases. Just a good guy, great guy. Him and I got along great. And I didn't talk to him much after the verdict was read, but while they were deliberating and even after the evidence was in, he seemed to be in very good spirits.
That didn't last long. Or maybe he's still good spirits. Maybe he's like, hey, you know what? That guy deserved that money. I feel good about this verdict because I felt bad about myself being a scumbag defense lawyer, hurting innocent people, denying them justice. So maybe it was a good come home for them. So George, here's another question. So you've done as we talked before the program, I saying out of all the people, have done training and done my boot camps, like you really stand out for somebody that's constantly working and training and trying to be better and putting themselves in the arena over these years that we've known each other. So if you were to give advice to, a freshly minted law school graduate just past the bar who has some bird brain idea that they want to become a trial lawyer, what advice would you give them?
Well, if they're committed to becoming a trial lawyer and they've made that decision that that's truly what they want to do, and they're not, driven by images of grandeur and witches, because those are very fleeting.
And a long way off.
Yes. I would say get a mentor. First and foremost, get a mentor. And that's a hard thing to do. It's easier said than done. I didn't start out going to my mentor and saying, "Will you be my mentor?" That's not how it started off at all. We first became friends and had a, decent, almost non-working relationship. And as I got to know him better, I decided that was somebody who had some skills that I wanted to emulate. So rule number 1, get a mentor. Or step 1, get a mentor. Step number 2, start training. Even if you can't find a mentor, start training. Where would you train? Well, number 1, going to things like TLU and and just hearing what other lawyers have done that have come before is a huge asset, but it's also just kind of dipping your foot in the pool, so to speak. Real training is going to come from getting up on your feet and trying to deliver on skills that you can practice through repetition, right? And at the end of the day, if you can't get up and do that in front of like 15 lawyers who are basically rooting for you, then how are you going to be able to do that in front of 30 people who really don't even want to be there and your client's depending on you? So get a mentor, start training, and start getting reps in. That'd be my advice.
And I got great news, George, because for people who have TLU on demand, also known as the Library for Trial, we're starting something actually this week called Trial Lab. And on Wednesday of this week, I'm going to do an hour of cross and an hour of performance skills with people who, subscribe to TLU on demand. That way they can actually start physically training. We do that once a week. And so that people can, because obviously coming to boot camps might not be in everybody's, it might not be everybody's budgets or the time constraints. But if it's not in your budget, because a boot camp, the tuition for the boot camps is $10,000, and so that's not in everybody's budget. But if you have a case that you're really working hard on, then HMR Servicing, who is provides funding for for cases, they'll loan you the money so that you can get the training. Or if it's like a lot of times, sometimes people do cases like and pay me the tuition on contingency. If it's a good case, I know they're going to make it. Well, I'm okay, but there's really, if you really want to be great, you have to train. You have to figure out the physicality of it. I got, the training videos to learn the fundamentals. And I think you can learn probably 70, 80% of the stuff by just watching and emulating and practicing it. But, to get to that stuff, that's the core, the stuff that final 20%, you got to have a coach. You got to get in person. You got to practice. There's nothing like actual reps in front of people. I tell people when you're training at home, just have one person there. One live human being will hold you accountable to your pacing, to your controlling your emotional state, to, all the things with the hand movements, the voice, the glance control, the creating space. But you got to practice all this stuff so that, it's important to to have the fundamental skills so you can practice all the time. You got to practice in everyday life. People are like, how do you do that? I'm like, how about when you go to the grocery store and that clerk has a crappy job making $12 an hour, 40 hours a week, and all they do is punch a clock and they're miserable. And you're like, instead of like, hey, can you help me find the milk or whatever you're looking for without any emotion? Excuse me, can you help me see if you can find the milk? And see if you can get that person, see if you can engage your mirror neurons and get their face to smile back at you, get them to like you. That, because you got to train all the time. And people say, most trial lawyers are the same people every day as they are in the courtroom. They're always looking for the next shit, always looking to train. George, I want to talk to you about how because as we talked about, you've done about 6 different boot camps, but how the skills that you've, continue to develop, how you applied the actual skills of presentation, performance, and connection in the various aspects of your trial. All right. But actually, before we get to that, I know and I appreciate you've been subscribing to TLU On Demand for quite some time, but how did you utilize On Demand to help you get prepared for this failure to accommodate trial?
Oh, yeah, that's a great question. So for this particular case, I remember that David DeRobertis did a recent trial on failure to accommodate against Marriott, and he did a whole case analysis on it, or a podcast on it. And so I went to it, and in particular, what I was looking for is what substantive topics did he talk to the jury about? Because kind of failure to accommodate is sort of, it's not something that most jurors walk in with, having had any experience with. So I listened to that and it gave me some ideas. Now, they're not, of course, trial is exactly identical, but it did give me some great ideas for framing about how he approached certain things. And so that really helped me frame some of my voir dire topics.
The Dark Arts Boot Camp, Omaha, Nebraska, September 9th through 13th. Dave Clark will teach you about the unconscious mind, conversational hypnosis, applying NLP to trial lawyering, how to embed stories in voir dire and throughout trial. And when you're not doing that, you'll be practicing with me and my coaches on your performance skills, creating the holograms, creating the connection, transporting the audience into the story so they just don't hear the story, but they actually experience it. There's still 2 spots left. We'll see you there. And speaking of voir dire, tell us about the voir dire environment in this particular courtroom.
So in this particular courtroom, he does this judge, great judge, he does a typical, it's not a typical 6-pack actually. He puts 12 jurors in the box and you have a panel of about 40. And he goes through the hardships, and then you're questioning just the 12 in the box, and he gives you 30 minutes to question 12, which isn't so bad. That's a fair amount of time, but you also have to be deliberate, and you have to have your objectives in mind, and you have to move with purpose.
And so when you first get up there, what do you when you first stand up and it's like, hey, plaintiff, you want to ask some questions? Like, as a matter of fact, I would like to ask a few questions, Your Honor. So when you first get up right out of the box, how do you start out?
So when I first stand up, the first thing I do before I say a word is I try to microconnect with every single one of the 12 that are in the box. And I also scan the other 30, right? Not as deliberately as I would microconnect with the 12 in the box, just to let them know I see them, I know they're there, and I'm not ignoring them.
Okay, and
That's
just by
before I say,
microconnect, just to be clear, so everybody understands what we're talking about, because it's to that's what to actually take a moment to look each juror in the eyes just for a moment, and then move on. So that in practice, once you get a little experience, you can look at 12 people in 3 seconds or less, and get a little connection with them. That's what we mean by microconnect, is getting a little connection and moving, so people start to get used and comfortable looking us and making eye contact, looking us in the eyes, because most people are not. Just want to be clear for the listeners. But go on. So after you get the little connection going, then where do you go from there?
And then it starts before I even say a word. After I've microconnected, you have consciously change the countenance of your face. Smile, right? Don't be overly joyed, because that doesn't match the energy in the room. Just go from a neutral to a warm face, as if you're saying, "Welcome. I'm so glad you're here," right? and they're not glad to be there, but you have to show that you are happy that they are, because at the end of the day, we need their help.
Right. Plus, we
So,
also, we can affect how people feel with our faces because everybody has mirror neurons. So, when somebody smiles at us, we're more likely to smile back at them or have a warm face back to them. And if we have a warm face back to somebody, then you know what? They're more likely to, when you make people smile at you, they like you. They can't help it. We're all wired that way. And, it's such an important skill to develop. And it just doesn't come naturally. I think as I tell folks, when we do boot camp, hey, you got to practice these skills in your life. You can't just practice when you're practicing. You have to practice every day. You get a chance to connect with people, whether it's the clerk at the store. You can say, hey, can you tell me where the milk's at? Or you can take a moment and consciously try to, ask it with a warmer face. Say, hey, can you please tell me where the milk is at? And have some warmth. And see if you can make that person who has that boring life, that grinding those hours out, if you can make them smile, right? That should be the challenge every day. How many people can I warm them up and make them and get them to have a little bit of smile towards me, and then I know I've changed the way they feel, and I can have. And now you start to gain confidence. I have the ability to infect and influence how people feel in this moment with this thing called my face. So, just something to keep practicing and keep in mind.
so by the way, that all takes place inside of 3 seconds. Everything we've
Right.
been talking about, all that stuff happens in 3 seconds. First thing is good morning everybody, and good morning everybody. As you scan them, you reintroduce yourself, because even though they've heard your name 3 or 4 times by now, they've forgotten it. And then I like to tell them there are 3 things that I hope we all can accomplish here today, and I need your help. The first is I need to hear from each and every one of you that's seated in these seats. Will this be okay? So right off the bat, I'm telling them I need to hear from all of them. And the second thing I'm asking is passively, will this be okay? Right? I do that intentionally because everybody nods and says, yeah, sure, that's fine. Great. The second thing I tell them is, now, if I do this correctly, all of you should be doing 90% of the talking, and I should be doing about 10% of the talking. But again, to make this happen, I need all of you to help me out with this. Will you please do this? Now I've gone from, is this okay, to will you please do this? It's not quite, it's a little bit more active, still a little passive, but I'm ramping up.
We
And
call
now
that
they
stepping,
understand.
George. Stepping. You made them make one
Now,
commitment. Now they're asking me to do a little bit more commitment. But after the first commitments, it's easier for them to do. They've agreed to participate. Now participate means talking. Okay, not just listening and being present, but also talking and sharing what you feel.
right.
Okay.
So I've told them I need to hear from all of them. I told them I want them to be doing most of the talking, and we're stepping. And then the third thing is, and I tell them, now the third thing that I need from each and every one of you, and this is going to be more on you than it is on me, so I really need your help with this, is I need you all to be brutally honest and tell us how you truly think and feel. Even if you think it's not what we want to hear, or you think it's going to hurt my feelings, or maybe you think it's just not nice. Either way, I want to hear all of it. So here's my question. Can you all do this? Right? Now I'm stepping up, and I want a physical affirmation that they've heard me, that they understand, and they agree. Now, all of this happens within about 2 minutes. If I had more time, if I wasn't compressed to 30 minutes, I could ask them, have they heard the term brutal honesty? What does it mean to them? I could get a more organic conversation going. But if I have to establish this piece in about 2 minutes or less, this is how I'm doing it. And when everybody raises their hand, some people don't, and the people that don't, I'll go back to them and I'll say, Miss Espinosa, will you do this for me? And she'll raise her hands. And then when she raises her hand, the other 2 or 3 that haven't raised their hands are like, oh, he's going to call on me if I don't. So they raise their hands too. Right?
Dude, I love, George, I love it. It's like we're going, because it's so much similar to all the stuff we trained on, with the longer scripts. But again, on the fourth one, getting the hand raised on the brutal honesty. So now we got him Yes, agreeing to participate. Yes, agreeing to talk. And now with the physicality, the stepping into the physicality and getting them used to raising their hands. And then the people that don't, calling them out just like they're in second grade and be like, oh, little Georgie, you're not participating. That's not acceptable. I got to point it out. And then all the other little Georgies didn't participate. They all raised their hand too. And now it's like everybody just learned. Class, I'm the teacher. You're the students. You're going to pay fucking attention. You're going to listen to me. And you're going to do what the fuck I tell you to do subtly. Because I'm the leader, and let's rock and roll. This is so you have 30 minutes. So what topics do you cover in your 30 minutes in this with this 12-pack?
So you want to make your first topic be something that's not super controversial, not going to draw a bunch of objections, but it's informing them about the case, right? So in this case, we're talking about reasonable accommodations, right? And the first question is, who here has had the experience where, or they've had a request, that maybe they've been hurt at work, or they know somebody that's been hurt at work, and they've required some type of accommodation. It could be a change to schedule, it could be a change to duties, assignment. And I want to hear from all of you if you've actually made that request. And a couple hands go up and you start talking about it. And again, you're not hunting for cause. You're just trying to get people talking about it while at the talking to you, while informing them a little bit about what the case is about, right? And get it and seeing what their opinions and their beliefs are, right? And at the same time, if someone's had a really bad experience, right, you don't necessarily assume, well, I've had a bad experience with my employer where they didn't accommodate me, that's necessarily a good juror for you, right? You're going to have to talk to them more because they might have had a bad experience with their employer and they got over it, moved forward with it, and they're not going to be very sympathetic to your client's plight, right? Then I moved on to who here has actually fielded or addressed requests for accommodations on behalf of an employer. This all happens in about 3 to 4 minutes. You want to talk to about 2 to 3 jurors per question. Before then you get into more real, or not real, but more important topics. Like, I want to talk to you about this concept of money for emotional distress. And in jury selection, it's not non-economic damages, it's emotional distress, because that's a triggering word, right? And you get people talking about that. Then after you get some beliefs on that, then you step up a little bit and you say, how about this idea of hearing or of awarding money for emotional distress if you're not going to hear from a doctor? Because we knew that we weren't going to have a doctor testifying in this case. So we wanted to get people's beliefs about that, right? Some people said, look, I'm okay with awarding money for emotional distress, but I'm going to need to hear from a doctor. Otherwise I can't do it. I'm not, and one juror in particular, I remember, got dismissed for cause because she said, if I don't hear from a doctor, I will not award money for emotional distress, even if you instruct me that there's no fixed standard for awarding money for emotional distress. And
Well,
then
that
I
was
moved
nice.
on.
Her honesty was nice. Gave her a chance to get off the jury and not have to use a cause challenge. So that was hopefully people that felt like her raised their hands too.
There were a couple, yeah.
Okay.
And I tell you one thing I picked up from going to TLU, and this I picked up from Raul Ravipudi, and it worked in this case, and I used it in this case, is when you have a series of jurors that you want to challenge for cause, do not start with your strongest cause challenge first. Start with your second, one that's pretty strong but not locked in. Start with them, because one or two things is going to happen. Either it's going to get granted or it's going to get denied. But if it gets granted, then you have momentum to challenge your first one. And if it doesn't get granted and it's denied, it's like, okay, well, Your Honor, clearly fine. That one was maybe a little bit borderline, but this other one, we can all agree that one's clear. That helped a lot. Another thing, and this I picked up also from TLU, and I heard Nick Rowley talk about it, and I've been too chicken to use it until this trial. But if you have a juror who is a good cause challenge for the defense, right? I'm already leaning in favor of your client. I mean, I can tell you right now, I've had really bad experiences with my employer. I've heard my friends had bad experiences with their employers. I just think employers are not looking out for employees, and I don't really need to hear the case. I'm already ready to give your client money. Something like that. Stipulate right out of the box that that person's gone first, right? That builds a lot of credibility with the judge, and it also gives a lot of credibility to your challenges when you're challenging people for cause. So that worked in this trial very well.
All right. And then, so you got your voir dire, you got 30 minutes. How long did the voir dire take?
It's interesting. We got 30 minutes to voir dire 12, and yet voir dire took a week in this case, Monday through Friday.
Why? So I came and watched a little bit of it, and it was just going so slow. I couldn't really, I couldn't stay long. I was like, wow.
Yeah.
Why did it take so long? If you only had 30 minutes to question, why did it take 5 days?
Part of it is the judge's schedule. This particular judge, he only heard trials. He heard them Monday through Friday, but the court's calendar was 11 to noon in the morning, 1:30 to 4:30 in the afternoon, with a 15 to 20 minute break in the afternoon. We rarely started at 11, right? And our breaks, and sometimes we didn't start at 1:30, and our breaks sometimes weren't 15 minutes or 20 minutes. Sometimes they were 30 minutes. So, it takes a long time. Also, when you challenge for cause, the judge was very deliberate. He wanted to hear at sidebar on every challenge, which I'm glad he did. And it also took the judge a while to work through all the hardships on a panel of about 40, just because he's pretty slow and deliberate. He didn't ask a lot of questions, but he dove deep on the questions he did ask, and so that took a while. It just took a while to get through it. And by the time it's exhausting, by the time you get into the second week and you're starting opening statements and you've already been in trial for a week, you're mentally, you're worn.
You're only going 3 hours a day, though, George. Okay, that's a nice part-time schedule. It's like a senior citizen schedule. Like Jerry Spence when he tried the Jeff Feiger trial. I remember he asked the judge if he could only do half days. He says, "Judge, I'm an old man. I need to keep my energy up." And the judge granted it. So the trial took like 2 months because he's only going 4 hours a day. But you know what? You're fresh the whole time, buddy. You're not getting worn out. So that's the great part. All right.
That's true.
Let's move on to cross-examination, because we've been working. At the boot camps, we've been working on we teach cross-examination. I'm trying to teach the fundamental skills of cross-examination. And, you've been doing this long enough that you remember when we used to teach the cross-examination of a, investigating police officer. Now, of course, we transitioned that to teaching the cross-examination of a defense medical expert. But, and the skills of cross that I believe are critical to master are, the basics of leading questions only, one new fact per question, looping, which means to establish a fact and repeat that fact in the next statement, cross-examining the present tense, which forces us as a cross-examiner to visualize the story, forces a witness to, but more importantly, allows our audience to picture or visualize the story, dropping the taglines like right, correct, isn't it true, or if you do use the tagline, to have a pause between your statement and the tagline. But I really think using the word true every time is better than correct or right, because correct and right end with consonants and the kind of a harsh sound, whereas true ends with a vowel and almost like a warmth. True. Plus, we want the truth. So I think it's a better tagline to use. And after you use it a few times, most people find they don't have to use it any more than that, because the witness, you raise your eyebrows and they answer. You don't have to say the word true. You're like, and it's like, okay, buddy, let's go. Let's continue this dance. And then, dropping all the filler words like and, so, okay. Using the flip chart, effectively using the flip chart. That means writing legibly. That means putting one topic per page. And also, as you get more comfortable, when you think about your crosses, you start to think about it. How am I going to use the chart? How am I going to fucking teach this jury this case through their witnesses? And so that's always a big step for people. Other things are, being intentional with your emotional state, just being curious when you're laying foundations, and being disappointed when you're impeaching or just showing what liars they are, but not getting angry and frustrated, because then you're losing control. And, and breathing, people get tense and they get aggressive in cross and they stop breathing, and then they speed up and their voice trails off and bad stuff happens. So those are really the core skills. So, so cross-examination here. So tell us about, things that you did in the cross that you thought were pretty effective.
So in this case, every witness we called were all adverse witnesses until our client, which was the only client or the only witness we had, on direct. So everybody in California, we have what's called the 776 witness, which is you're calling up an adverse witness in your case in chief. So cross-examination was key because everybody was getting crossed, and
Right.
not everybody's. Here's the thing: it's not a one-size-fits-all cross-examination, right? In other words, the main villain of our story was this deputy chief, right? This deputy chief of police, and he gets a very different cross-examination than, say, like a bureaucrat who's kind of removed from the facts, who's just walking through policies. You don't want to beat that person up. But by the same token, you need to get your story out. You need to get your admissions out. And all the techniques that we talk about are super helpful, are super and are great to use. You got to think of them like different arrows in your quiver, right? Which particular arrow am I going to fire at this particular target? So, for example, the first main villain, the 776. I knew for a fact that this guy, because on his depot transcript, never gave you an answer that was less than 4 pages long. This guy is just going to go forever. Okay. And if you're telling the judge, objection, move to strike, non-responsive, it makes it look like you don't have control of the witness. It makes it look like you're scared of what they have to say and that you can't control what it is you're trying to accomplish. So tell the story in active present tense through your questions. Let them have whatever diarrhea of the mouth, and then go right to the document that impeaches him, that it's so you're telling your story through the questions and the documents, and he just happens to be there. And the more he can't answer the question directly, the more evasive he looks. So it was very helpful to build the questions in present tense, one new fact per question, and just tell the story through your questions in the documents. That was one technique I used with him, or that we used with him.
How about flip charts? How did you utilize flip charts or did you in any of your cross?
I did, and we did. And the interesting story about flip charts, especially for me, is I used to see lawyers walk in with flip charts and I'd be like, why would you need that? What good is that? I mean, they seem so low tech, so old school. And now
Well, they definitely are low tech, and there's that they are low tech and old school.
Yeah, but I'm a big believer in them, and they're super effective because it's something that you build together in the presence of the jury. And once you figure out how you can use them in your particular case, they're so effective. So yes, we did use flip charts in this case.
But how did you use it though? You said once you figure out how to use them, they're so effective. So how did you use your flip charts to be so effective?
So there are a couple of ways. One way in this particular case is I knew the deputy chief, who's our main villain in this case, I knew he was going to lie about what other people told him or said in this case. So when I'd ask him, what did, again, open-ended, and I knew he was going to lie about it because I had his depot. What did witness A tell you? Witness A told me X. Okay. So you go to the flip chart, right? And while you're doing that, you're walking across the courtroom. It's creating interest. You flip it over. It makes a lot of noise. People are looking. Okay. Take out the marker and you write his name across the top. Write the date. Then put witness A, X. Okay. That's your testimony. Yes. Did we understand it correctly? Yes. Okay. Move on. Okay. Next day, flip chart is flipped and it's just a blank sheet of paper. Okay. The next day, so now we're 2 days later, witness X comes to the stand, right? Did you ever tell Deputy Chief so-and-so? A? I don't recall ever telling him that. Walk over to the flip chart. Flip it back over. Witness X. A. Take a red marker out. Cross it out. Move on. Points made, right? You've established the guy's been lying. Okay? That was one way we used it. A second way to use it is when you're pulling information from a bunch of different documents, right? And it's kind of confusing. You build it together, right? So you take information from one document, another information from another document, and then another information from another document, and you've summarized 3 documents in a very simple way, which is really important in employment cases when you're talking about different policies and what they mean and how they're supposed to work. And it's very easy to get lost in it. A flip chart is a very easy, concise way to get information from multiple sources into one place.
After you demonstrated your effectiveness with the flip chart, the defense attorney, did they effectively use a flip chart in their case too?
Yeah, that's kind of funny. That's the funny thing about flip charts, right? Because when it always creates, be first to use them if you can, and use them with confidence, because so this particular opposing counsel, or the senior partner that was on the case, there's 2 of them, but the senior partner, and he told me on break, he looked at that flip chart. He's like, well, I'm not going anywhere near that thing now that you used it. And of course, sure enough, the next day he did go to it and he did write on it. But like if you're going to use it, you got to be prepared. So he used the quartz marker to write something on the flip chart. Why does that matter? Well, because the quartz marker's been there since 1986 and it runs out of ink halfway through. Okay. Secondly, it's not very legible. It's like you could tell he wasn't writing it, he hadn't practiced this. And thirdly, it was nothing new or controversial that he was writing up there. It was something that we all basically have accepted as true. So what's the point of writing it up there? I mean, it's not in dispute. So it wasn't very effective. And what I will also say about using a flip chart, if you're going to use a flip chart, the first time you're writing whatever it is you're writing on it should not be live in front of the jury. Okay? If you're going to use a flip chart, I'll go through and I'll have like 10 or 12 different drafts of what I want to write on that flip chart, like on just an 8.5 by 11 sheet of paper. And then once I've written it out on that 8.5 by 11, I actually go to the flip chart, a practice flip chart, and try to recreate it 2 or 3 times so that I know exactly where the words are supposed to fit, right? Because otherwise, you get these sentences that kind of like start kind of drooping at the end, or maybe they don't quite fit. And so you have to like kind of crunch the words in. And it just, I'm not saying it loses all effectiveness if you do that, but it's certainly much more effective if you're pre-programmed and you're planned.
Right. And because like we train with flip charts, it's, training how to write legibly, training how to, put one topic per page, spacing out the information so that one topic covers the whole page, and effectively controlling when the jury looks at it, and, how you build the story with the flip chart. I mean, and that takes practice, and that practice breeds confidence and calmness when you're under the heat of battle of trial. Let me ask you, was there any witnesses that, came up that, required you to pivot that perhaps you weren't totally, ready for?
Yes, in that, as civil lawyers, typically we have the benefit of having depot transcripts for a lot of witnesses.
Well, every witness that you want them for, right? I mean, you could take a
Well, that you
deposition of
want 'em
anybody you
for.
want.
Right. But particularly if you're subbing in or associating into a case kind of late and you didn't have the ability to dictate which depots you're taking, sometimes you have witnesses that take the stand where you don't have a deposition transcript, right?
Did that happen
And
here?
it did happen here. It happened here with a human resources investigator who was basically going to take the stand and wax eloquent about how, hey, look, all the stuff that the plaintiff is complaining about, we investigated it and we couldn't substantiate any of the allegations that he's making. And so we looked into it, and, there's no there kind of thing, right? So what we did there is, as soon as she takes the stand, and we didn't call her in our case, the defense called them in their case. And what had happened in this case is the defense had actually produced, they claimed inadvertently, attorney-client communications between this investigator and their general counsel about the investigation that they allegedly performed. Well, as soon as she took the stand, I mean, we weren't planning on using those emails until this investigator took the stand. As soon as she took the stand and she was done, I stood up in cross and got to use essentially the script that we've gone over together maybe hundreds of times on conducting a proper investigation. And, it went something like this. Miss So-and-so, you're a human resources professional for the district? Yes, I am. How long have you been a human resources professional? Well, for the district, about 10 years, but in total, about 30 years. So as a human resources professional with 30 years of experience, you're trained on how to conduct a proper investigation. True? Sure. By proper, or that an investigation must be complete. Well, I don't know what you mean by complete. Well, turn and face the jury. When we say complete, what we mean is that you want to talk to all the witnesses. Oh, yeah, I generally agree with that. Miss So-and-so, you're also trained, and you know that a proper investigation must not only be complete, but it must also be objective. Yeah, I'd agree with that. Right? And by objective, what we mean is you're not predisposed to one side or the other. You're just going to follow the evidence wherever it leads. Yeah, I'd agree with that. And you go through that and you establish, and of course you say complete, and then you have a third thing, which whatever it is, accurate, doesn't really matter. The point is that you can show through her and through the documents that the investigation was not complete, and it was not objective, and it was not accurate. And of course, you don't need a deposition transcript for that. And by the way, all this happened in the span of about 20 to 30 minute cross, and it was very effective.
And so you have to practice in the deposition. You practice in motion hearings. You practice at the grocery store. That's why you have a family. You practice on them. You have to keep the skill up or it erodes. It's simple as that.
Somebody give us an overview of this case.
Or I call wowing it. And what I mean by wisdom of the wise is, why are we still right in spite of this fact?
These are just some of the clips when I was cross-examined 10 years ago, remember that.
About 11 o'clock at night, and he leaves this message. I got a brilliant idea. Every conversation he starts, I have a brilliant idea.
Well, welcome everybody. We've got a good crowd here today.
George, as we've, kind of worked together since 2022, we've been knowing each other about 3.5 years now. And, obviously you're continue to try cases and do these arbitrations, which are sort of like bench trials, which you still have to perform in. But in addition to just actually doing that work, what are you doing in between the trials and the arbitrations to work on consistently improving your skill set?
Well, just in everyday life, I mean, you want to be intentional when you're meeting somebody, working on making that eye contact with them, pausing, taking, being cognizant of, the emotional congruence on your face. Am I neutral right now? Am I conveying to this person that I'm happy to be talking to them, or that I'm glad that I'm talking to them? I mean, and that's actually kind of a challenge for me, because my general predisposition is a lot of times if I'm not working, I kind of want to be left alone. So I have to really be intentional about.
You have like a resting grumpy face.
Yes, I've been told. So I've been told. And so
yes,
I intentionally do that.
Continue to remind you of that, so that way if you have a resting warm face, you'll be in a better mood all the time, George. Like right now, you have a little tiny crack of a smile. It puts you in a better mood. You can't help it.
It's a big smile for me.
Just a little smile. Big smile is bigger mood. But anyways.
So that's what I do kind of on a daily basis. I try to at least do that with some regularity in my everyday life. I definitely keep coming back to the boot camps. The boot camps are a great way to intentionally practice, like I said, with other like-minded individuals that are all focused on getting better.
Right. And, with the boot camp now, because the case that we're really, teaching for most of the boot camp now is this, motorcycle truck crash case with, it's a wrongful death, and using a Google map, because every vehicular case that anybody's ever had, they have to, everybody uses a Google map, right? To show the roadways and show the configuration. Well, since everybody uses that map, it seems like it might be a good idea to teach people the best practices on how to use that Google map in an opening statement, in a cross-examination, in a direct, because that way they get more comfortable with it, just like you got more comfortable with your flip chart. And so, I'm, pretty stoked about that, but it's like, but it's also, if you do a boot camp, then you got 6 weeks of practice where you're going to have to, record yourself doing things intentionally, taking the time to practice, so that way you improve and start to learn these skills of connection and presentation. And so that way, when you actually, because nobody's going to train hard on it. I mean, we're not just going to sit down for a day and practice. But if you sign for boot camp, you're going to be there for 5 days. You're going to practice your skills and practice on your case. And so that just continuing practice, it's like becoming a black belt. Nobody becomes a black belt in a week or a month. If you want to become a lethal weapon with your body, it's going to take years of discipline training. And I think it's the same thing about being a trial lawyer, because it's the training of the brain and the body and everything, the neuromuscular system, to be a performer in the courtroom is really what, the training's all about. So got to keep up the word, and there's not enough time to we're not professional athletes. Professional athletes get the liberty of practicing 5 hours a day and having to perform, a couple times a week. Whereas we have to constantly perform, so we don't get that liberty to practice. So we have to practice while we work. Is this what, I guess is really what I'm saying. We got to practice while we work, right? And you're coming to boot camp with Joe Freed at the Paseo, August 12th through 16th, which I'm super stoked about, just as a juror, but, because it's obviously it's trucking. It's not your bailiwick of employment or products. And so it doesn't really, but it's just being around, like, all these, because I think there's 15 participants coming, yep, and 9 jurors, and 10 with George. So George is going to bless us. And then, after that, we got the dark arts, September 9th through 13th with Dave Clark, who's my mentor. So that's like a combination of case strategy and case, how to structure the case, how to structure the voir dires, and the performance skills. And then, in September, we're doing one in Long Beach. I think it's the 23rd through the 27th. It's just performance skills. So it's like all these different varieties of different types of boot camp. Lucky for you, that one's in your neighborhood too, George. You see how lucky you are to live in Orange County? You didn't realize how lucky you were, did you?
I did not. All the training that's coming my way.
There you go. All that accessibility. That's why I can't wait to move back to California at the end of the year. So, George, we're going to wrap this program up like we have. Let me see. So that verdict was $3 million in non-economic damages. So that's, is that right?
That's right.
That's pretty dope. And what was I going to say? George, how do people get a hold of you if they need to get a hold of you?
Oh, my cell phone is 714-904-1669. Anyone's welcome to contact me on my cell phone. You can email me, georgem@logmapc.com.
Oh, that's a real easy email.
Well,
George M. Moschopoulos, whatever the fuck it is. All right.
Yeah,
Cell phone's probably the easiest.
Yeah,
All right.
cell phone's probably the easiest way. I'm not hiding, but I kind of am hiding. I don't have a social media presence. I'm not. So if you're looking for me on the gram or on Twitter,
you're not gonna find George. You're gonna find George on his cell phone. Old school. All right, good. Now, George. And if anybody needs a hold of me for anything, my cell, of course, is 248-808-3130 or dan@triallawyersuniversity.com. And if anybody's listening to this wants to, a complimentary 30-day access to TLU on demand, just shoot me a text or email and I will send it to you, so that way you can, because it's an app for your phone, so you can learn anytime, anywhere, and we collect all the pleadings, transcripts, and PowerPoints. So it's sort of like a library for trial. Okay, so you're going to be the defense medical expert, all right? You're going to be Dr. Moschopoulos.
All right.
Right. Because that way, this is like, so for the cross, we train this pattern cross, right? Even though you don't have defense medical experts for the most part in your employment case. But once you master the pattern, then you can extrapolate to any cross. It doesn't matter, because you have the fundamental skills and you have the structure, the right way versus the wrong way. And once you do this cross, what you're saying, by laying this cross down is you're calling the defense medical expert a lying sack of shit in front of the jury without calling them a lying sack of shit. But you create the tension and the drama with the cross. So the jury leans in and they pay a lot closer attention when you do this cross, I believe. So, and, it's great because when Panish uses this cross, like in his depots, and he goes, I call this the Ambrose chapter. I'm like, I feel honored, Brian. Thank you very much. You ready, George?
I'm ready.
Doctor, you're a board certified medical expert.
Yes.
To become board certified, this requires advanced education.
It does.
This education, it takes place both during medical school and after you get out.
Yes.
But while you are in medical school, you do take classes.
That's right.
One of the classes that you take is on how to conduct a proper medical evaluation.
Right.
You're trained that a proper medical evaluation, it must be impartial.
Yes.
Now, this is where I'd write it on the flip chart. If we had a flip chart here and we were in court, I'd have a butcher paper. The first page would be white, blank, and I flip it over and it says proper, and then I write number 1, impartial, in capital letters, and it takes up the entire line, and then I put a number 2 underneath it, and I space it out to make sure that my 3 points are going to take up the whole page. Now we're going to go on and define impartial. By impartial, what we mean is that you're not an advocate for either side.
That's right.
Doctor, you're trained that a proper medical evaluation, it must not only be impartial, not turn and look at it, but it must also be objective.
That's true.
By objective, what we mean is that you don't cherry pick the evidence to support a desired opinion.
That's right.
Doctor, you're trained that a proper medical evaluation must not only be impartial and objective, but it must also be complete.
That's true.
By complete, what we mean is that you consider all relevant information.
Right.
Doctor, the opposite of a proper medical evaluation, one that's impartial, objective, and complete, well, that would be a biased evaluation.
That's right.
Doctor, you're training, that there are certain risks associated with a paid expert's choice to conduct a biased medical evaluation.
Oh, I don't know what you mean.
Well, what I mean is that one of those risks is that the jury could be misinformed about the patient's condition.
I guess that's true.
Doctor, you're trained and you know that if a paid expert chooses to conduct a biased medical evaluation, not only could the jury be misinformed about the patient's condition, but they could also be misled as to the extent of the patient's injuries.
That's a risk.
Okay, so on my paper, I already flipped a page and it says bias and it says misinformed, misled, which is an example of stepping. And now we have to get to the third step. Doctor, you're trained and you know that if a paid expert chooses to conduct a biased medical evaluation, not only could our jury be misinformed about the patient's condition and misled as to the extent of the patient's injuries, but perhaps worst of all, they could be deceived into undervaluing the human harms and suffering that were caused.
I guess that's a possibility.
So, doctor, let me ask you this question. So that's called the refocusing mover. Here's my question. So I strongly recommend at the end of every topic or chapter of Cross that you finish it off with this refocusing move. It lets the jury know, folks, the 25 questions I just asked before this one, this is why I asked it. To walk at this witness down the hallway, to shut the doors, to get to the goal fact that I don't care what their answer is because I win either way because of logic. So let me ask you this question. On December 17th, 2022, you had a choice to make. So why don't you tell us all, what did you choose to do?
I have no idea what you mean.
Well, what I mean is, did you choose to do a proper medical evaluation, one that was not, I flipped the paper, flips over, one that was impartial, objective, and complete, like you were trained to do? Or did you choose to do a biased evaluation, knowing, and I flipped the page back over, knowing all the risks.
Oh, I did a proper investigation.
The proper, so doctor, so you want this jury to believe you did a proper medical evaluation. Now I get to flip the page back over, so it makes a bunch of noise. Why don't you come up here and just put your initials right here? But anyways, so that cross-examination should, if you master that cross, first of all, draws a line in the sand if you actually use it. Second of all, as you can see, it's a structure. So George did a similar structure, but he changed it. He didn't use impartial, objective, complete. He used other words, but then he went and defined those other words. So that way you get to lay the groundwork for what these words mean in this courtroom. And that's the important part, is you get to define them. But then once you learn those skills, then you can apply the same skills to telling the story of the case, right? Because the idea of cross is to tell your story through the adverse witnesses, one new fact at a time. So it's building the story. You're building the case right in front of the jury. So in the trucking case, because also an important skill in cross is learning how to create space. So in the trucking case, if nobody knows what the opening trucking statement is, but they'll know what the opening statement is right after I cross you. So now you're going to be the defendant trucker George, right? Trucker George, now I want to talk to you about the day that you're driving south on US 411 and the day my client dies, okay?
All right.
So Trucker George, you're driving south and you get off the freeway. You get off the freeway and come to a stop. True?
Yes. Okay.
You
Yes.
stopped because you want to cross over the US 411 going south to get onto the I-75 ramp to go down to I-75.
That's right.
While you're waiting, you look down to your right and you see, and it's dark out, right? So you see a set of headlights coming at you and you know that's a car.
That's right.
But so you wait. And you wait for those headlights to see if they're coming on your highway or if they're going to get off onto the ramp onto I-75.
Right.
As you're waiting, you see those headlights, and they actually do get off on the ramp, the first set.
That's right.
So you take your foot off the brake, and you step on the gas, and you move your truck just a couple feet forward.
That's right.
And while your truck is a couple of feet forward into the roadway, you look down to your right again, and you see another set of headlights coming at you.
That's right.
So you continue to wait to see what those headlights are going to do.
That's right.
And they also get off the road onto the I-75 ramp.
That's true.
And then you see a single headlight, but instead of waiting, you decide to take your foot off the brake and to step on the gas again, and you get about halfway across the road when you see a flash of light in your rearview mirror and you hear a thunk. True?
Well, I didn't see the light when I entered the intersection.
Right. Because if you would have saw the light and then you pulled your truck out in front of the motorcycle and intentionally tried to kill him, well, that would be murder, right?
I guess that's right.
But because even though, and we all see the light, now you've seen the video from your dash cam, so you know the light of the motorcycle is perfectly visible.
It's there. It was there. Yes.
It was there. And so after you hear after you see the flash of light and you hear the thunk, that's when you pull your truck over and you get out and you get down from your truck and then you head back across the road.
That's right.
And when you get back across the road, you see the blue and silver motorcycle on the ground. And about 30 feet from that motorcycle, you see a body. The body of the motorcycle rider. Driver.
That's true.
And when you look closely, you can see a pool of blood around the man's head.
Yes, I did see that.
And that's when you get out your phone, and the first person you call isn't an ambulance. It isn't the police. It's the risk manager at ABC Trucking.
I did call the risk manager at ABC.
And you tell him that you've been in a terrible accident, and this guy hit your truck, and that you don't think his light was on, and that you never saw him, and that you don't think it was your fault.
That's right. I did say that.
And upon hearing this, the risk manager tells you, hey, you need to stay calm, but make sure you call the police and you let them know that it wasn't your fault.
That's right.
And you never saw him.
That's right.
And when you do call the police, the dispatcher, after you tell the dispatcher what happened, the dispatcher tells you just stay calm. They try to actually calm you down, even though you're the one that just committed these. You're not the dead guy. They stay calm. They're going to have an officer there just as fast as they can. True?
That's true.
And it's about 10 minutes later when Officer O'Brien pulls up and he gets out of his car and he heads over, and you're watching this and you see him head over to the body that's of the motorcycle rider on the ground.
That's right. Yes.
And you see him bend down and check for a pulse.
I did see that.
And then he gets up and he walks over towards you.
He did.
And when he comes over to you, he asks you, to explain what happened. And he's, pointing over to the motorcycle rider and asks you how did it happen.
He did ask me how it happened.
And again, you repeat the same story, that you never saw him, you don't think his light was on, and of course it wasn't your fault.
I did say that.
All right, so anyways, George, that's the same cross-examination, so that way, so once you practice looping and stuff, you easily start to loop every time, which means starting the new question where the last question ends. It's like a trail of breadcrumbs. Easy story to follow. That's the exact opening that we teach, with the visuals. If this was a real cross, I would have used the visuals for it. I don't have my Google map with me, but you got to practice doing it and stuff, and practice on, depositions too, because you can use the same board on the depositions, and that way you get practice using it right in front of them. And so, anyways, George, and in March in Rogers, Arkansas, we are doing Depositions Our Trial live at Satch Oliver's Ranch. So that's gonna be a pretty cool. I'm really excited for that one. Like these location ones, going out to like a ranch in the middle of like, a rural place like Arkansas. It's going to be like a new experience. What a clever idea, huh? A ranch and a cowboy? Cowboy trial lawyers? I like it. I like it a lot. George, it's been great hanging out with
sir.
you. I know you got your family there in Nicaragua, and I'm up here at the AAJ in San Francisco. So there's the Belli conference today. So I got to get going down to that. And you know what? I'll see you August 11th, hopefully for dinner, if you can make it, or August 12th, whenever you get there. Sound good? What'd you say, George?
Sounds great.
All right.
Sounds great. I will see you in less than. Thanks for doing
George.
this.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.